RICO status is absurd and fails to meet the case law supporting non-party opposition to unlicensed investigations. Tennessee courts have consistently upheld the importance of licensure in the private investigation field. In Tennessee v. Duncan, 11S.W.3d 882, Tennessee 1999, the court held that private individuals or entities conducting investigations without proper licensure are not only acting illegally but are subject to both civil and criminal penalties. Any evidence gathered in such a manner is inadmissible in court. Moreover, the courts have ruled that only those properly licensed can claim interference with an investigation. In Smith v. State Board of Private Investigators, 145S.W.3d 714, Tennessee CT App, 2003, the court dismissed claims brought by an unlicensed investigator due to lack of standing. Legal standard. The plaintiff's attempt to claim RICO, Racketeer Influenced and Corrupt Organizations Act, status in this case is not only unfounded but absurd. The defendants in this case are two YouTube content creators who are engaged in public commentary. There is no common business tie or ongoing enterprise linking the defendants to any alleged unlawful activity, nor is there any evidence of 1. Existence of an enterprise, a group of persons associated together for a common purpose of engaging in a course of conduct. 2. Pattern of racketeering activity, at least 2 acts of racketeering activity committed within a 10-year period. 3. Connection to the enterprise, the defendant must have conducted or participated in the conduct of the enterprise's affairs through the pattern of racketeering activity. The plaintiff's allegations fail to meet even the most basic elements of a RICO claim. There is no evidence to suggest the existence of any enterprise involving the defendants. The defendants are independent YouTube creators, and there is no common business or legal relationship between them. In Seville Industry Machinery Corporation v. Southmost Machinery Corporation, 742 F.2d 786, 3d CIR 1984, the Third Circuit defined an enterprise as an entity composed of individuals or entities tied together through a common purpose. The court explained that the enterprise must have an existence separate and apart from the pattern of activity in which it engages. The plaintiffs have not and cannot demonstrate that any such ongoing entity or enterprise. Instead, the defendants are merely individuals providing commentary, which does not rise to the level of a coordinated criminal enterprise. Further, in Taubes v. Taubes, 47 F.3d 1280, 3d CIR 1995, the court reaffirmed that RICO claims require proof of a pattern of racketeering activity. The pattern must consist of multiple related acts of criminality that present a threat of continued criminal activity. Here, the plaintiffs have provided no evidence of racketeering activity or any ongoing criminal conduct by the defendants. The notion that YouTube commentary constitutes racketeering is an overreach and a gross misuse of the RICO statute. Moreover, Pennsylvania courts have been clear in setting a high bar for civil RICO claims. In Kohler v. Preferred Real Estate Investments Incorporated, 361 F. Apex 354, 3d CIR 2010, the court held that speculative allegations and unfounded accusations are insufficient to establish a RICO claim. In this case, the plaintiffs rely on conjecture and hyperbolic claims of interference, without demonstrating any pattern of criminal behavior or an ongoing enterprise involving the defendants. Given that the defendants are independent content creators with no common business or enterprise relationship, and that the plaintiffs fail to demonstrate any pattern of racketeering activity or other criminal conduct, their RICO claim falls well short of the legal standard. The plaintiff's misuse of RICO in this context trivializes the statute and fails to meet the rigorous requirements set by Pennsylvania and federal courts for civil RICO actions. 3. Conclusion. The plaintiff's motion for preliminary injunction should be denied. They fail to meet the requirements for injunctive relief, lack standing as licensed investigators, and have not demonstrated that their case has any merit. Their illegal activities as unlicensed investigators should not be protected, and granting an injunction would harm the public interest by silencing critical reporting on a matter of public concern. Moreover, this meritless legal filing appears to be nothing more than a publicity stunt orchestrated by a parolee, Nick Hatzistathia, and an unemployed reality television figure, Dwayne Dog Chapman, whose career has long since faded. They are now resorting, with the help of publicity-seeking lawyers, to gain the public's attention at the expense of a missing 15-year-old boy from Hendersonville, Tennessee. Such conduct is not only improper but an abuse of the legal system, and it must not be allowed to proceed under the guise of a legitimate legal action. For these reasons, the motion for injunctive relief should be denied in its entirety.